Hello, good evening, Chicago. My name is Jesse Lanshe. I'm appearing on behalf of Arab American Family Services for tonight's episode of the Domestic Violence Hotline. You are watching an interactive call-in program brought to you live on cable channel CAN TV 21 and online at cantv.org/hotline. During the next 25 minutes, we're going to be discussing the legal aspects of domestic violence, and I invite you to call in with your questions at 312-738-1060. Our phone lines are now open. Joining me tonight is Chicago attorney Claire McMahon. Hello, Claire. Welcome to the show.
Thank you for having me.
All right, Claire, you practice in family law, is that right?
Yes, I do.
And you have some experience with domestic violence?
Unfortunately, yes, I do.
When a client first approaches you with a domestic violence situation, what kind of options do you discuss that might be available to them?
Well, usually when they call me with a domestic violence situation, clients don't really know that that's what they've got happening. Oftentimes they tell me about, when you come to a divorce lawyer or you come to a lawyer to help you with a parentage situation, at some point you talk a little bit about what the situation is with the relationship with the other adult in the relationship, whether it be your spouse, the significant other, ex-boyfriend or girlfriend, what have you. And oftentimes when they come to me, they don't even realize the level of abuse that has happened. There might have been one physical incident and a lot of verbal and emotional incidents. And when you tell them, it sounds like you're really in a very unsafe environment, and I think that you should consider getting an order of protection. Most of those people are surprised. Oftentimes these situations start out slowly and sort of snowball into something larger and larger, much like our big storm on Sunday.
Sure.
And so people don't really realize that they're in this terrible situation until it's sort of too late.
Well, when they come to you, do you suggest immediately that they go to the police or that they rush to the courthouse? What do you think is the first line of defense in situations like this?
Well, it really depends on the level of danger. If someone comes to me and it sounds like they are in a situation of serious physical endangerment on a regular and daily basis, I will tell them to go to the police, make a report, and then go to the courthouse. And the reason why is because oftentimes, if it's after hours, they can get instant relief from the police that they cannot get by going to the courthouse. You can only get an order of protection when the courthouse is open. And the courthouse is generally only open around sometime between 8:30 and 4:30, Monday through Friday. So you call me at 5 o'clock on a Friday and you've got a big black eye and your arm is broken, I'm going to tell you to go to the police because they might be in a position to arrest the assailant immediately as opposed to you going home to an unsafe environment for 3 days until Monday morning.
Again, if you're just joining us, this is the Domestic Violence Hotline. We are accepting calls, and you can reach us at 312-738-1060. And again, this show is sponsored by Arab American Family Services. The contact information is on your screen. If you'd like to contact them, please feel free to reach out to them. Their address is 9044 South Octavia in Bridgeview. They can also be reached at 708-599-AAFS, that's 2237, or they can be reached via email at info@americanfamilyservices.org. Claire, you mentioned an order of protection. What type of conduct is prohibited by an order of protection?
Well, not only is there a type of conduct that is prohibited, there is also it also has to be conduct made by people who have a certain kind of relationship to you. So not only is physical abuse prohibited, also verbal abuse, the kind of abuse that would limit you economically. So say taking away money, taking away a vehicle, making it so that you don't have the resources that you need to be able to live a basic daily life. In addition, other things that are prohibited are taking out your abuse on individuals such as minor children that are in your care, disabled adults in your care, and also pets.
What type of relief is obtainable via an order of protection? For example, can you make sure that the abusing person is barred from the place where you live?
Yes, you can. You can, even if you're not the person who owns a house, there are instances in which you would be entitled to be the one to stay in the home, and they would be required to vacate the home. In addition, you can also get relief from them contacting you in any way. You can get relief from them abusing you financially or abusing a disabled adult or minor child financially. For example, stealing disability checks, things of the like. Also, you can have them not be allowed to contact you. You can stop or limit visitation. You can stop them from going to your place of work, a child's school or after-school activities, retrieving a child from, say, a babysitter or a daycare center. The kind of relief you can get is really very profound. There's a lot of relief to create a safe haven environment and safe haven physical locale for you, as well as lack of contact and not allowing them to come near you within a certain parameter, sometimes 500 feet, depends on the circumstances, not be allowed to hit you or touch you, things of that nature.
Do you have to tell this person before you seek relief or help from the court?
Not always. You can always go in and seek relief without telling the person first. Whether or not the court will give you the relief is a different question that's a little more complicated. But in instances where there really is a lot of abuse going on and the abuse is emergent, it's the kind of thing where if the person knew that you had planned to do this, they might attempt to stop you or harm you or prohibit you, say, from leaving the house. Courts will generally grant the relief.
In your experience, and certainly domestic violence is a serious issue, have you seen instances where people abuse the system instead? Instead of having a genuine fear, that they use it for strategic purposes?
I've never had a client come to me and ask for one where I felt that they were not in genuine fear for their health and safety and welfare personally. I have seen instances of it in the court. I do know attorneys who have had to grapple with whether or not that is what's going on. And I certainly think that there are instances where it's sort of just a combative situation and it's not clear exactly whether there's an abuser and a victim, but maybe there's this terrible cycle that this relationship has gone into. I do know that it does happen, and if you do it and you get caught, you can owe attorney's fees as well as have other adverse issues happen to you. For example, if you attempt to use it to inappropriately gain custody over minor children, generally those children will be taken from you.
Oh, well, that's unfortunate, certainly.
In addition, before I move forward, I would just, because I think it's something we sort of brushed over, a big thing that's very important with domestic violence is that you have to have the right kind of relationship to the person in order to be able to get the order. If not, you have to meet elements under a different statute, under, say, a no stalking order. So, for example, Jesse, you and I know each other as colleagues. We're both attorneys. We've worked on cases together, but we don't have a romantic relationship. We're not married. We don't have any children together, and we're not related in any way. Okay, so the thing is that if we had an issue that occurred between you and I would not be able to, and of course you would not be able to, get an order for an order of protection under the Domestic Violence Act because we don't have the right kind of relationship. And that's something that people should keep in mind, is that just because there's terrible things happening doesn't mean that this is the act that's going to help them, because there's each law has its own requirements of what's needed to meet it. And so this is one of those situations where, you can't just get it if you're, say, being harassed by a neighbor. That neighbor would, say, have to be an ex-boyfriend as well, for example.
So our viewers should keep in mind that many of the things we're discussing tonight are only to be considered under the Domestic Violence Act. And certainly, if you do have further questions, you should reach out to either an attorney or the Arab American Family Services, who are sponsoring this program. Again, if you're just joining us, this program is in association with Arab American Family Services. Their contact information is listed on your screen. Additionally, you can call into our show. We are accepting phone calls, and we can be reached at 312-738-1060. Claire, we have talked about going to the court, going to the police. Are there agencies set up where someone can go stay, or is there other relief that you can take that you don't have to get the police or the court involved to help remove yourself from a domestic violence type situation? Absolutely.
My feeling is that if you're not safe in your own home, you should leave. I don't think that you should risk your own physical safety because you think that fighting over your apartment or your house is really worthwhile. You can go to a shelter. There are a number of them in the Chicago area. There are a number of helpline numbers that you can call. Many of these shelters will even have buses or vans that will come and pick you up. They oftentimes have volunteer staff available to pick people up from, public places if they have those resources available to them. I'd recommend that if you are concerned for your health and welfare and your safety that you go stay with friends or family. Sometimes, depending on how serious the abuse is, staying with friends and family could just mean that they're going to attack you and your friends and family, which is really one of the reasons why these shelters are so valuable, because they're hidden. Their addresses are not public. They don't tell people, they don't advertise their location, and so they can be very safe if you have a very serious situation.
So if you're trying to keep a potential abuser away from you, it's permitted by the court to keep your location a secret?
Absolutely. And in fact, there's the forms to fill out for an order of protection are really designed for what's called a pro se litigant. That is, they're designed for someone who's not a lawyer, who doesn't have a lot of legal background, who maybe isn't as familiar with the law, to be able to ask the court for relief. So that's sort of filled out with all these check boxes where it tells you what to fill into each place and asks you to check which things do you think apply to you. And one of the things you can check is to not give away your address because you fear for your safety. And that's on the very first page of both the petition and the order.
Oh, that's good information to know. Coupled with an order of protection, are you able to get custody of children via this vehicle, or child support, or alimony?
Yes and no. The first time, if you go in on an emergency order of protection where you've not given prior notice to the other party, to the respondent, is what they're legally called, you cannot get custody, okay? You can, however, get possession, which means you can get an order that says that you can keep the children with you, but you can't get an order that says that you have the right to make decisions about, say, medical and health care and, education and all of that. As the case progresses, once the other side has the opportunity to be served by the sheriff and have notice of the proceedings and come into court and tell their side of the story, you can get custody through this vehicle.
Oh, okay.
as well as child support, maintenance, payments back to a shelter if you stayed at a shelter. There's a wide variety of very powerful relief that you can get through this kind of litigation.
So, and earlier you mentioned the different kinds of relationships that are covered by orders of protection. Oftentimes, an order of protection is within a divorce case or a parentage case.
Yes.
Can you explain sort of the situation, practically speaking, of how one would take the order of protection into consideration with an underlying case such as a divorce or a parentage case?
Well, so there's a couple things to keep in mind here. One is that these domestic violence cases are under their own statute, so you're not required to say have a child together in order to bring one. And what that means is that you can go and get one at any time. Okay. Not only can you go and get one at any time, you can get one at any courthouse. So let's say you have a child with someone, you were never married. Let's say you have a parentage case running and your judge is down at the Daily Center in downtown. Well, if you don't live near the downtown courthouse, say if you live by the Markham courthouse or you live by the Mayview or Skokie courthouse, you can go to your local courthouse and get your order of protection, order to protect you. You don't have to go down to that judge. You can go to any judge available in any local courthouse. That said, once you've done that, if it's you and the other parent of this child, and the child is also part of this, it's going to make a lot of sense for all of this to go before your judge in the parentage court so that all of the issues can be addressed at once. Because not only do you have this domestic violence issue where you need to protect yourself, but obviously there's long-term implications to someone in that kind of arena being an abuser that's going to affect issues of custody, and custody can affect issues of child support and payment. And if they're refusing payment or if they've, locked you out of resources and you need to have court-ordered resources, oftentimes it's best to have all of this handled in one venue. And so what you can do is you can take the domestic violence case that you filed in, say, the Markham courthouse or, the Skokie courthouse or what have you, and you can, what's called consolidating, you can consolidate that into your case at your parentage case downtown so that everything goes before that judge. One of the nice things about that is that then you have about half as many court dates.
Sure.
The downside, of course, is that the judge that you first spoke with the first time that you went and got your order of protection is not going to be the judge who's going to hear your final order of protection, because everything will get heard by your parentage judge.
But certainly it would be advisable, if possible, to have one judge handle all of these things so that one judge is apprised of all the relevant facts. Is that right?
I would think so, yes. I mean, I think there may be some instances where it's not worthwhile. If you have a very busy judge, you might just want to have your plenary order entered right away. If you go to, say, the Markham Courthouse and you bring your civil order of protection and the state's attorney reviews the case and decides it's substantial enough that they want to bring charges, you may not be able to consolidate because you can't consolidate criminal cases into civil matters. It's just one of those things that the state's attorney doesn't really do. And so there might be a reason to leave it separate in such an instance like that where, if it's egregious enough, it breaks the law. But for the most part, I would say yes. And the reason why is because issues of domestic violence are relevant to issues of custody and parenting time, even if the domestic violence doesn't happen in front of the child. So having that, if you've got a domestic violence issue between you and your former boyfriend, girlfriend, even if the child didn't see what happened, I think it's still worthwhile to ensure that your main judge is apprised of those issues. And the judges both in the parentage courts and in the divorce courts, as well as in the probate courts, are all very well versed in these issues. These are things that come before them on a regular basis. And so, you really should feel confident that the judge that you have is going to have adequate training to be able to handle this. You don't have to have a judge over, say, in the domestic violence courthouse to be able to have someone do a good job on your order of protection.
All right, if you're just joining us, again, this is the Domestic Violence Hotline, sponsored by Arab American Family Services. Here's their contact information if you'd like to reach out to them for some more information. And again, we are also accepting calls now at 312-738-1060. Claire, earlier you mentioned what's called a plenary order of protection, and before that you mentioned an emergency order of protection. Can you walk us through the different types that are available?
Absolutely. There's three basic types of order of protection. And there's two, well, let me step back. There's two types of order of protection. There's civil orders of protection and criminal orders of protection. And both of them have subtypes, okay? One is your emergency order. Your emergency order is what happens the first day you come in, you fill out your petition, you go right before the judge that day. The judge hears your case and listens to your story. And if you meet the elements under the statute, then they'll enter what's called an emergency order of protection. That generally lasts no less than 14 days, and no more than 21 days. Okay, so you're going to be back to court in less than a month. Okay, and during that time, the respondent, the person who is the purported abuser, is going to be served by the sheriff and be apprised of what the next court date is. Okay, so once that happens, you're going to come back to court, and one of two things can happen. One, your case can be continued to a future date. Two, your case can go to hearing that day, and you can have a final order entered. Now, if you have a final order entered, that order is called a plenary order. Okay, and the plenary order can last no more than 2 years. But it's a final order. You don't have to come back to court again unless there's some reason to modify it. Say, you move residences, that you're moving out of state or something, something big happens. The respondent needs to be able to, has changed employment and needs to be able to be on the same block as you because they now work next door or something, which would, I think, raise some red flags. But sure, in theory, I guess could happen. Things of that nature. Or, there's a child and visitation has to occur or something. Okay? So that's a plenary order. If the plenary order isn't entered, that is, if you don't have a final hearing where everybody gets to tell their story, then you get what's called an interim order, okay? And the interim order basically just leaves everything, you can put some changes in it, say visitation, if, you guys can come to that, or, if that issue has to be addressed. But that's a sort of a middle ground order that carries you throughout the case to your final date so you can have a final hearing on the case. Or, of course, unless you two come to an agreement or you choose to abandon your order of protection. Oh, and I'm sorry. And criminal cases work the same way. The difference is that if you report it and the state's attorney takes it, you're no longer the petitioner. You're now the victim, and the petitioner is the state. That's the big difference, really.
All right. What mechanisms are in place to keep someone to follow the rules of an order of protection? What punishments might be in place if somebody were to disobey the order of protection?
That's a very good question. There's a couple different ways that you can handle that, and what I would say is this. There's two ways. One is that you bring a motion before the court and tell the court that the other person violated the order of protection. I don't think that's the best way to handle it. I think the best way to handle it is that if you have an abuser who has violated an order of protection, that you call the police. Okay? Even civil orders of protection are quasi-criminal. And what that means is that although they're civil, the state is not involved, violation of them is considered a low-level crime. Okay, so if the other person, if you have an order of protection and say the person named as the respondent, all right, shows up to your place of work or, tries to call you, you call the police and the police will arrest them. And they will arrest them, they will have to go through processing, they will have to bond out, and then the state's attorney, sometimes it can go back into the civil case, but for the most part, the state's attorney will then instead take that case about the issue of the violation, regardless of what happens on your emergency order or interim order or plenary order, whatever happens in that court section. It's like because it's a crime in and of itself, it's a whole new case. And the state's attorney will take that and they will prosecute the issue of whether or not the violation was really a crime. I mean, for example, they dialed the wrong number, they didn't know you were there. I mean, there might be a reasonable excuse, but for the most part, if they show up at your house, there's really not a reasonable excuse.
If the violation is willful.
Yes.
Yeah. All right. Well, we are running out of time, so maybe just time for one more question. We previously talked about custody and visitation issues and how they sort of interact with this. What are your experiences with limiting or restricting visitation with children and an abuser?
My personal experience is that when you go in for an emergency order of protection and there's an issue of abuse, most of the time, if the issue extends in any way to the children, most of the time the judge is going to either limit or at least reserve visitation for some period of time, at least until they come back. And the reason why is because that way the abuser doesn't have the ability to use the children in order to hurt you. And in addition, they can also award very specific visitation, Saturdays from 8 to 5 or something. So there really is a lot of leeway for ensuring that both the safety of the children and their continued relationship with the other party.
All right. Well, Claire, I want to thank you for coming on the show and sharing your time with us. And again, for the viewers at home, this program has been made possible in part by support from the law offices of Claire McMahon, as well as Lanshe Law, LLC. Claire, again, thank you very much for appearing on the show.
You're very welcome. Pleasure.
And if anyone out there wants some additional information, please feel free to reach out to Arab American Family Services at the contact information that was given out previously.